It is no secret that organizations in the crypto industry have often clashed with authorities, with Ripple's current lawsuit vs. the SEC being probably the most noteworthy example. However, the SEC is now suing even larger people in the crypto business. Binance and Coinbase, two crypto juggernauts, have become the latest to dispute with us authorities. With the imminent debut of FedNow, an innovative quick payment service, the United States Federal Reserve, Fed, is ready to transform the nation's financial transactions. The Fed launched the service in 2019 and hopes to have it operational by July 2023. The FedNow service is intended to facilitate speedy cash transfers across the nation's financial institutions, representing a significant advancement in contemporary banking technology. Beginning in April, the Fed will begin certifying participating banks in preparation for the launch. Banks interested in participating will need to participate in a consumer testing and certification procedure influenced by the FedNow pilot program's lessons learned. The data gathered will help early adopting institutions fine-tune their systems before actual transactions begin. Ken Montgomery, first Vice President of the Federal Reserve Bank of Boston and FedNow program leader, has issued a call to action. He has advised financial institutions to prepare for the upcoming launch, adding that the FedNow service is available to all licensed banks in the United States. This development occurs amid a background of increased interest in blockchain-based alternatives. Ripple, a blockchain firm closely tied with the XRP cryptocurrency, is one such solution aiming to provide cost-effective, real-time cross-border payment solutions for banks. Ripple's liquidity hub enables banks to use XRP to move funds, resulting in instantaneous transactions. Stellar Lumens, a blockchain-based payment network that provides a faster and more inexpensive means of conducting global payments, is another prominent company in this field. FedNow, on the other hand, looks to be a threat to these blockchain alternatives. According to the Metal blockchain team, the integration of FedNow with Metal blockchain enables for quick conversion between money and stablecoins, marking a major step toward integrating conventional banking with decentralized finance. FedNow is now positioned as a possible competitor to current cross-border payment systems like as Ripple's XRP and Stellar Lumens, Elm, as well as numerous stablecoins. FedNow's attraction stems from its capacity to offer a speedier, less expensive alternative to the rather clunky centralized payment system that now takes days to process payments, even on business days. With this, attorney John Deaton, the creator of CryptoLaw, took to Twitter to explain the significance of Judge Annalisa Torres' summary judgment ruling in the SEC vs. Ripple litigation. The comment was made by attorney Deaton in response to a tweet by prominent Bitcoin YouTuber Scott Melker. Melker stated in a tweet today that if Americans do not fight back against the SEC's outrageous overreach, they would be limited to trading just 4 cryptocurrencies on Wall Street. Run exchanges: Bitcoin BTC, Ethereum, Litecoin Cash, and Bitcoin Cash, BATE. Notably, Melker cited the 4 crypto assets since SEC Chair Gary Gensler earlier referred to them as commodities while referring to other tokens as securities. Furthermore, Melker said that the 4 digital currencies are the only ones traded on the X exchange, a recently formed crypto trading platform sponsored by Wall Street heavyweights such as Fidelity Digital Investments, Charles Schwab, and Citadel Securities. In response to the tweet, attorney Deaton said that Judge Torres' judgment becomes potentially more relevant with each passing day. He said that if the court rules against XRP, it would be status quo, with greater political clout for those promoting anti-crypto campaigns such as Gensler, Warren Buffett, and Rep. Brad Sherman. Deaton, on the other hand, believes that if Judge Torres rules in favor of XRP, it would be good news for other crypto assets and the whole market. Meanwhile, the SEC has maintained authority over the whole cryptocurrency sector. According to Gensler, all crypto assets other than Bitcoin are securities as previously reported. Following his statement, the SEC launched a broad investigation on cryptocurrency-related firms saying that they violated securities laws. The SEC sued Coinbase and Binance last month with enabling the trade of unregistered securities such as ADA, SOL, Matic, and Algo. Remember that the SEC says XRP is a security, which brings the coin's secondary market transaction into question. Notably, Judge Torres is likely to make a decision on whether XRP secondary market transactions qualify as securities. If the court determines that XRP is not a security, it will set a legal precedent that calls the SEC's jurisdiction to regulate a large chunk of the market into question. As a result, other token issuers might use the judgment and claim that their particular crypto assets are not securities. As the SEC's UV's Ripple case nears its conclusion, members of the XRP community have been asking several concerns about the case. Aside from when the litigation will conclude, the XRP community has been curious about how Judge Torres would issue the verdict. Interestingly, in a recent CryptoLaw broadcast, CryptoLaw founding attorney John Deaton answered this crucial topic. Attorney Deaton ruled out the prospect of Judge Torres disclosing her summary judgment ruling to solely the SEC and Ripple. A lot of people are curious about how this summary judgment verdict will be revealed. Is she planning to inform Ripple and the SEC? No way. Deaton was reported as saying, according to the Pro-XRP Council, Judge Torres will issue the summary ruling in the public docket. According to Deaton, the judgment will be made public in the same manner as earlier decisions in the case, including Judge Torres' decision on the Dubert expert motion. We'll get the filings in the public docket just like we got Hyman's emails and other rulings, Deaton added. He also said that the public would be informed of the verdicts at the same time. However, the CryptoLaw founder said that the judgment will be sent to the Ripple and SEC attorneys engaged in the case. Deaton emphasized that the decision might be sent to the parties involved in the case through email a few minutes before the public knows about it. Furthermore, Deaton said that the United States District Court for the Southern District of New York often deals with financial-related issues and understands how crucial information is exploited for insider trading. Because the court is aware that anyone may engage in insider trading utilizing major judgments such as the summary judgment in the SEC EVs. Ripple litigation, it will guarantee that the Ripple lawsuit's ultimate conclusion remains a top secret. As a result, Deaton claims that no one will have preliminary knowledge about the ruling's substance before it is made public. It's worth mentioning that attorney Deaton recently published a broadcast in response to certain questions about the case's ultimate ruling. As previously reported, Deaton predicted that any of the parties that lose in summary judgment will appeal the decision. He indicated that the matter might be taken all the way to the Supreme